Thank you very much, Honorable President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize. Hearing of appeal in CCJ Civil Appeal BZCV number 1 of 2020 between Speednet Communications Limited and the Public Utilities Commission. Today's panel comprised their honors, Mr. Justice Saunders, President and the Presiding Judge.
Good morning, Councillor.
Mr. Justice Witt.
Good morning, Council.
Madam Justice Rajnath Lee.
Good morning, Council.
Mr. Justice Burgess.
Good morning, Council.
And Mr. Justice Jamada.
Good morning, Council.
May we have the appearances, please? Thank you very much.
May it please the court. Eamon Courtney for the appellant. Appearing with me is Ms. Priscilla Banner. Appearing for the respondent are my learned friends, Mr. Fred Lumore, Senior Counsel, and Ms. Sheena Pitts.
Good morning again, Councillor. Mr. Courtney, I gather that you wanted to make a preliminary submission.
Your Honor, Mr. President, we have filed an application yesterday for the respondent to be sanctioned pursuant to the rules. That application is supported by the affidavit of Daphne McFadden. The essence of it, Your Honors, is that yesterday we were served with what is described as the speaking note, being some 51 pages and 491 pages of authorities. Your Honors, in my respectful submission, that document is the submission of the respondent. It is markedly different from the submissions filed on time as ordered by the court in case management. I respectfully submit that that is the submission. And if that is so, then it is out of time. Your Honors, that document, which describes itself as a speaking note, has some 23 authorities. Of those 23, I believe only one has been referred to before. All the others are entirely new, and therefore goes well beyond the submissions that were made in accordance with the case management order and to which the appellant has replied. The rules provide, Your Honor, that if a party does not file its submissions in accordance with the case management orders, then it is not to be heard on the hearing of the appeal unless the court grants leave. I'm not aware that any application for leave has been made for the respondent to rely on these submissions. I'm not aware that any application has been made for relief from that sanction. And we ask this court to impose the sanction because what has happened really is to make a mockery of the case management order of this honorable court. Submissions were filed, I believe, on the 30th of July, and we responded. And now we are called upon today, one day before the hearing of the appeal, to meet a substantially new and different case. It is obvious, Your Honors, in closing, that we have had absolutely no time to read, to study, to respond to all these new authorities. This is vintage trial by ambush. And the only appropriate sanction is that which is provided in Rule 14.4. The respondent should not be heard on this appeal. In essence, Your Honor, that is the submission. I believe the court will have had our application supported by the affidavit and the very short speaking note.
Mr. Courtney, you said it is a substantially new and different case, but you haven't given us the respects in which it is new and different.
Your Honors, The short answer to that is, if the court looks at the reply submissions which we filed, we indicated to the court, and I'll just, that reply submission appears at page 1027 of the record. At paragraph 2 of those reply submissions, if the court is with me,
Yes.
I pointed out that the respondents' written submissions are largely descriptive and set out selected statutory provisions and quotations from the transcript of proceedings. In extenso, we observed the following. Paragraphs 1 to 12 is an introduction, 13 to 26 falls under the title The Facts, 27 to 40, representations of Speednet, 41 to 49, a description of the case of Speednet, 50 to 60, the statutory scheme, 61 to 62, proceedings at first instance, 63 to 72, the rubric, under the rubric in the Court of Appeal. This court will, on reading the submissions, appreciate that they are not responsive to the written case advanced by the appellant. So they did not respond to our submissions at all. They just filed something in order to meet the deadline. We took that point. And now, Your Honors, what we have is a 51-page response to our case, supported by 23 authorities, which we have not had an opportunity to read. So that this document that was supposedly their submissions is not responsive. Now they are responding to the case. Had they put that in on the 30th, then my reply would not have been only 5 pages. It would have responded substantively to what my learned friends now seek to advance.
I noticed as I looked at the 51-page document myself that the first few paragraphs are consumed with some technical issues of certiorari. Were those points raised before?
No, Your Honor.
They weren't raised before the trial judge or the Court of Appeal?
No.
Yes, Mr. Lumo, how do you respond to this?
Good morning, Your Honors. The first, I will also refer to the reply of the appellants, which starts, I'm looking at from page 1028. What the appellants have done, what counsel has done, is that from paragraph 3 of the reply, they stated that it is telling that the written submissions of the respondent provide no legal analysis on the following important issues which are germane to the appeal. And then they listed 4 items, which reads why having regard to the contents of the letter dated 29th July 2013, the applicable statutory provisions, this court should conclude that the PUC had issued a license to Speednet within the meaning of the Telecommunication Act on the 29th of July 2013. And it goes on in B to say which provision of the BTA authorizes the PUC to license Speednet to lawfully use the 700 megahertz band for mobile services, whilst that portion of radio frequency spectrum is assigned to broadcasting. 3, why the amended spectrum allocation plan was not disclosed to the Court of Appeal, and in any event, what is the effect of the belated publication on this appeal? And finally, on what legal basis should the PUC be permitted to depart from its repeatedly stated position that Speednet authorization would be formalized after publication of the amended spectrum allocation plan, and the license fees will become payable. Since Council took those issues, we decided that if those are going to be an issue which the court will require us to address in order to reach a decision, then we should address them. Hence, the expanded speaking note. Your Honors, also the technical issues containing the application were taken before the Court of Appeal, where we said the declaration sought and the facts in the declaration are not factually correct.
No, but did you submit to the Court of Appeal that, or to the trial judge, that the remedy of certiorari was not available because Speednet was not an adverse party? Was not a party that was adversely affected?
Affected, yes. Not in those words.
Yeah, but you can't raise them here for the first time, Mr. Lumor.
Well, there is the issue decided by the trial judge. She used the word having substantial interest. But the rules go back beyond that to say, when you say you have substantial interest, they break it down to include whether the person is adversely affected. And that point was taken by the trial judge. And a finding was made on it.
But Mr. Luxmore, if you are taking that point, is the effect of your submission that they have no locus standi because these are JR proceedings? Isn't that the point you're making?
Yes.
So that is a preliminary point. On the reading of the papers before the trial judge, you wanted to argue that they can't start because they have no locus. They don't meet the CPR requirements for JR. They are not a party adversely affected. Strike out the claim. Is that what you want us to do?
Yes, but I have to acknowledge that we did not make an application in those clear terms to the trial judge.
Or before the Court of Appeal?
Or before the Court of Appeal. All we said was that the order sought is not factually correct.
Well,
Mr. Lumor,
yeah, go ahead, Justice Ashanti.
yes, thank you, President. Mr. Lumor, I'm trying to follow what you just said. Is it because you saw certain things that Speednet put in their reply and you thought you had to answer those things? So you did 51 pages of written submissions and call it a speaking note?
They are in this speaking note because if they were written submissions, I think they would have been more expansive than that.
Mr. Lumo, at some point in our rules, we would need to address this issue of speaking notes because it can't be right that we could give directions for written submissions, and after those submissions have been put in, the day before the trial, someone presents a 51-page document and calls it a speaking note. And it is a document that it goes completely outside what is in the written submissions. This is in effect a new set of written submissions. And I agree with Mr. Courtney that it's a kind of ambush. Not it is a kind of, it is an ambush because you are asking not just him, but the court, because we prepare before the day of the hearing. You are asking us now to have to read these new cases and to consider new grounds or points on which to determine the merits of this case. This is something which we deprecate. We can't support this at all. As to the point which really is a point in limine, we will not allow you to raise that point at all. As to the rest of what is described as a speaking note, at the end of the day, when we are going to give our decision on this matter, we would take into account certainly the fact that whatever is a new submission really ought not to be considered by us. But we can't encourage parties to, at the day before the trial, issue a new set of written submissions and expect that the trial would be a fair one.
Your Honors, may I say that it was sent to my learned friends not on Wednesday, it was sent on Tuesday. What I intend to propose to the court was maybe for the court to consider whether at the end of the submissions, Mr. Courtney can be allowed some time to send in to the court his views or further submissions on the points that we have raised.
Mr. Luxmore, before the President answers that, may I just ask a question for my own clarification? In addition to the point in limine, have you raised any other new points in this latest reply? So you have agreed before us that it is the first time you have expressly raised the point in limine that they have no local standi because they are not adversely affected. You've accepted that, right?
Yes.
I just want to ask you for the record whether there are any other, because these are your submissions, are there any other new points that you have sought to raise in this note to us?
There are no new points.
No other new points?
Yes, absolutely, there are no other new points.
All right.
Mm-hmm.
Thank you.
Okay, well, we will proceed, and we are going to reserve our position on this issue. We wouldn't hear you on that preliminary point about the certiorari point, but we would allow you to expand your arguments, and then we will see at the end when we deliberate on this matter.
Your
Mr.
Honor,
Courtney. Yes, Mr. Courtney.
could I just record that? So I take it that my application is dismissed?
No.
Honor,
Your application, we haven't ruled on your application, save that portion of it which would implicitly relate to the point about the certiorari and the adverse effect, whether you're a party adversely affected or not. The rest of your application, we have reserved our position on it.
Your Honor, I just wish to indicate that it is unclear to me whether or not Mr. Lamore will be allowed to rely on these authorities, which I have not read, which I'm ambushed by, and whether I am, how do I respond? I mean, quite frankly, the rules speak to this issue very clearly, and a sanction is imposed and a procedure is made, set out in the rules for Mr. Lamore to seek relief from sanction, giving this court an explanation. He has said that he expanded his submissions because of what I put in my reply. Your Honors, the 4 points that are in the reply are the 4 issues that I raised in my submissions. They go to the core of the appeal. And therefore, Mr. Lamore cannot say that he was not aware that these are issues. These are the issues. The 2013 letter, is that a license? He has not responded to that. So he can't say that that was what this whole case is about.
Was there any response to that in the Court of Appeal?
That was the center of the argument on both sides, and the court will recall that the Court of Appeal came to the conclusion that it constitutes a provisional license, and both of us are now saying to this court that the Court of Appeal was wrong in reaching that conclusion. That was the whole issue from the very beginning, whether or not that is now a license, and therefore the license fees are due. There is the whole question of the amended spectrum plan, which was published on the 6th of October 2018, which was addressed fully in my submissions. Mr. Lumor is saying, oh, he's now seeing that, and therefore he has to put in a speaking note. All of these are issues which were germane and directly canvassed by us below and presented in my speaking note. I am now put in the extremely prejudicial position where I'm going to have to listen to submissions by my learned friend presented to me yesterday, where I have not wrapped my mind around them, whether I have not had an opportunity to determine whether I should reframe, recast, de-emphasize, overemphasize tactical issues. And I'm being told, having complied with the rules, that I must go away from today and write something later on and send it to the court. To be honest, with due respect, Mr. Lumor's client is in breach of the rules, manifestly so, and yet I am the one that is being treated unfairly. I do not understand how it can be right and proper where the rules sanction Mr. Lumor. And the court is saying, we will go ahead and we will at the end of it decide what we do. I don't know what I'm here to meet today.
But you are the party, Mr. Courtney, that has the burden of seeking to reverse a judgment which is against you. So that is a burden you always would have, whether Mr. Lumor said anything at all, whether he chose not to put in any written submissions, you would still have the onus of asking us and convincing us that we should set aside the judgment of the Court of Appeal, because that judgment is against your client, so that you are still required to so persuade us, irrespective of whether Mr. Lumor sent in submissions or not.
Your Honor, I accept that, except that there is one distinction in this case, which is a bit unusual, in that both Mr. Lumor and I are saying the Court of Appeal is wrong. So both of us start from the position that the conclusion reached by the Court of Appeal is one we both are urging this court to say is wrong. So I accept that there is a burden on me, and Your Honor, I'm prepared to present that. What I'm saying to the court, and I believe all of us are aware of this, submissions are made, oral submissions are made, taking on board what your opponent is saying and the way they have deployed their case. It is unfair for me to make my submissions. My learned friend has had my submissions for many, many weeks. He has seen my reply many, many weeks. And now I am in the dark being asked to present my case. He will present a case which I received yesterday and have not read. And then I must, weeks after this, go and write something and send it to the court. Your Honor, I do not, with the greatest of respect, and this is, I will end here, I do not conduct advocacy like this. I need to know mentally what I'm doing so that I can tactically assist the court and defend the rights of my client. It is very unfair to me, very unfair. My learned friend has my submission for weeks. I don't have his. And I don't see why I am the one that is being in effect sanctioned. Proceed in the dark.
Mr. Courtney, may I ask you something? There is a cross appeal in this case, is there not?
Yes, Your Honor.
In Mr. Lumor's submissions, does he advance his case on his cross appeal?
Your Honor, again,
I'm just asking. You don't have to take me through the detail. I'm asking you. Not his recent submissions, you know, in his compliant submissions.
Your Honor, he has put in some submissions, and the answer to the question is yes, and I have responded to those.
Okay. Yeah.
And I have responded to them.
and there isn't overlap between that and these submissions that are contained in the speaking note?
Your Honor, as I understand it, what Mr. Lamore is replying to in the speaking note are the 4 points that I mentioned in reply rather than supporting his cross appeal, as I understood what he told the court.
But Mr. Courtney, the real prejudice to you, which I think we all accept, is that if we press on today and you have no opportunity to respond, you will be disadvantaged. But if you have a fair and adequate opportunity to respond, which is not ideal, obviously, it's not ideal for us, it's not ideal for anybody, but if that is the course we adopt, then would that not mitigate the unfairness towards you, if any?
Your Honor, I don't wish to repeat and to take up the court's time. I just say to the court that I feel disadvantaged as an advocate. I am being asked to make my submissions without tactically, strategically knowing what my learned friend is saying. It is unfair to me, and I do not accept, from an advocacy point of view, that that is remedied and mitigated by telling me some weeks or months from now I can put something in writing. But I'm
so what is it that you want us to do, Mr. Courtney? To say that he mustn't give any submissions? You alone should submit and then we decide afterwards?
Well, you know, Your Honor, the rules, that's why I keep going back to my application. The rules speak to this issue. Mr. Lamore should put in an application for relief from sanction. And if he can satisfy the court that there is a good reason why the sanction imposed by the rules should not be imposed and should be lifted, then he gets that and then the court takes it from there. That is a procedure that is set out in the rules that I have come to deal with this morning. That is what the rules provide.
And remind us again, what is the sanction set out in the rules?
Rule 14.4 says where a party has not filed and offered to exchange the party's written submission within the time or times specified by the court, he or she shall not be heard at the hearing of the appeal, except with the leave of the court.
But you see, Mr. Courtney, there's a little technical challenge with that. Mr. Lamore did put in something. So he's not strictly a party who has not filed. What he has done is he has filed something that he himself has recognized is not sufficient and has come at the 11th hour to expand. So this is, it's not exactly within the four corners of the party who has not filed. But be that as it may, Mr. Courtney, if we have to entertain an application for relief from sanctions, it means that this hearing has to be put off. It may be that an appropriate order for the cost of today may be and Mr. Lamore may volunteer that given the situation. In other words, the costs that are sustained as a consequence of this late filing, could that meet the justice? So in other words, but what we call typically consequential costs, costs that follow as a result of this lateness, would that even the scale somewhat? And then we press on today. Here, at least you, as the president has said, argue why you should succeed on the appeal, why the Court of Appeal is wrong. Mr. Lamore advances within his 40 minutes, whatever he wants, barring the preliminary point, which the president has been clear on. You get a fair opportunity to respond. It must be fair and reasonable to you. And Mr. Lamore accepts, we hope, in those circumstances, that the additional costs incurred as a consequence of this lateness be met by, I don't know if he wants to meet them personally or his client meets them, he will volunteer that information. Is that a way forward in a sort of pragmatic way to move on with this matter today? Because at the end of the day, we have to try and do justice and mitigate, to be fair to all parties.
Your Honor, I can only repeat to the court, one, that the rules speak to what should happen today. And I have made the appropriate application, and I am urging this court to make Mr. Lamore do what the rules require him to do. One. Two, speaking as an advocate, I am prejudiced and disadvantaged because I have 491 pages of authorities, 51 pages of supposed note that I have not read, and I would like to wrap my mind around it before I make my submissions. That is what this court ordered in its case management order, that Mr. Lamore presents his case in time. It is unfair to me as an advocate to not know what he's going to say. I'm repeating it, and I've put the position, cost, Your Honor, does not go to the way in which I conduct advocacy. But it's a matter for the court.
Okay, we take a brief recess. I'm asking you not to press the red button, stay in the court and don't exit. And the judges will confer among ourselves, and we'll come back to you.
Oblige, Your Honor.
Your Honor, President, I wanted to say that if it will satisfy my learned friend, I am prepared to pay 20% of the cost of the proceedings, whatever that amount would be, for the late filing, and say to the court that I don't expect to see myself in this position again.
The court will take a brief recess, and I ask you not to exit the call. I'm just waiting to ensure that we are all here. And I think we are. Mr. Lumor. Mr. Lumor, are you hearing me?
I'm hearing you,
Yes.
Your Honor.
Okay, we have discussed this matter and we take a very dim view, quite frankly, of the filing of this speaking note. In effect, we agree with Mr. Courtney that it is not a speaking note. It really is written submissions that are added to the submissions which were earlier filed. Now, the effect of this is that you have, as again, Mr. Courtney said, put him in an awkward position, an untenable position. You've also put the court in an untenable position. And this is simply not on. We can't encourage this. It's not something which is, which represents good practice. And therefore, we would have to effect a sanction on you. In fact, a series of sanctions. Given that what is at stake here are large sums of money and also issues of statutory interpretation that would have precedental value, we wouldn't be able to proceed today. We are going to adjourn this matter until the 14th of October. You're going to have to pay the costs for today, the costs that have been thrown away, and we want those costs paid before the end of September. Mr. Courtney, do you have any figure in mind now for what those costs would be that would be suitable for senior counsel, of course?
Yeah,
And Mr. Courtney, maybe also the cost, not just for today, but as you
consequential
said,
costs.
Yeah, you have to prepare or redesign maybe your oral decision, your oral arguments. So that what the price for that would also be something that needs to be paid.
And I believe, Mr. Courtney, you will have to file further submissions. So you should factor those in as well.
All right. Your Honors, could you give Mr. Lamora and I 24 hours, or at least until Monday? I'm sure we will be able to agree that.
Very well. So we will give you until Monday to agree those costs. If you can't agree, then we would receive from you by Wednesday a 1 or 2 page document which sets out your respective views on it. And then after we receive that document, we ourselves will determine a figure. But we want those costs paid before, on or before the end of September. When would you be able, well, failing which, Mr. Lumor, you wouldn't be heard on the 14th of October when the matter comes up. When would you be able to put in your written submissions, Mr. Courtney?
Your Honor, I crave the court's indulgence, quite frankly. I have a substantial appeal on the 17th of August, and I would like to take, some time off after that. So if I could be given maybe to the middle of September.
Middle of September. That's fine. 15th of September, what day is that? 15th of September is a Tuesday, so that's fine. 15th of September.
Obliged.
We won't be requiring any further submissions from you, Mr. Lumor. You've already had 2 bites at the cherry. So the orders of the court are that 1, this case is adjourned to the 14th of October. The parties are to meet and to agree, if possible, the costs thrown away for the day and the consequential costs which have arisen as a result of the filing of this speaking note. If the parties are unable to agree, they are to file by Wednesday, which is the 5th of August, their respective submissions, well, not so much submissions, but figures in relation to the costs thrown away and the consequential costs that will accrue. And the court will ultimately, in that event, because we are hoping that you will agree, but if you can't, you file it by Wednesday, the 5th of August, the court would ultimately determine what those figures are, and those figures as determined by the court or as agreed by you, those amounts will be paid by the PUC, Public Utilities Commission, to Speednet on or before the 30th of September. If those costs are not paid, the court will not hear counsel for the Utilities Commission on the 14th of October. On the 14th of October, naturally, we begin at the normal time, 11 in Belize, and 11 our time and 9 a.m. in Belize.
Mr.
Appellant's written
Courtney's,
submissions.
yes, submissions.
The appellant's written
And
submissions.
Mr. Courtney's submissions are to be filed by the 15th of September.
And after that, no other documents will be filed without leave of the court. And certainly not speaking notes.
Yes, no other document without leave of the court. Is there anything else?
Not for the appellants. Much obliged, Your Honors.
Mr. Lumo?
Nothing from the respondents.
Yes. Well, I believe that our registry staff would have captured the orders of the court, and in due course, those will be reduced to writing and be issued to you. But there are some things which were made very clear, and you don't need to wait for the order in order to activate them.
Mr. President, there was one thing I think that was discussed. The new matter in those submissions on the local standard.
In any event, those issues that relate to the technical points on the certiorari, we would not entertain those issues. So you don't need to respond to those issues, Mr. Courtney.
Much obliged, Your Honors.
Mr. President, I heard Mr. Luma say he had nothing to say anymore, but I thought I would have heard some kind of apology to the court.
Certainly, Your Honor, I'm sincerely, I apologize for putting the court in this position whereby we are unable to proceed today, and all the inconvenience caused to the court and the court staff. My sincere apologies.
Yes.
And what about your learned friend, Mr. Lumor?
Oh, so sorry. And I apologize to Your Honor, all of you, the whole court, and to my learned friends, Mr. Courtney and Priscilla Banner, for the inconvenience caused. It's deeply regretted.
Yes. I would tell you, Mr. Lumo, the only thing that gave us pause in this matter is the fact that giving Mr. Courtney the relief that he was seeking was not so straightforward, given that you did in fact file a written submissions within the time frame which they should have been filed, and those written submissions covered or purported to cover a cross appeal by you. But the court really takes a very dim view of this. I perhaps can count on one hand the number of times we have adjourned a matter which has been set down for hearing. It's not something that we like to do. It's not something that we normally do. And you could consider yourself very fortunate that in this particular case, we opted to make the orders that we are making. But that is how it is. So we adjourn until the 14th of October. Madam Deputy Registrar.
Thank you, Honorable President Saunders. This court stands adjourned. Thank you.
Yes, thank you.